Hi, this is Red Tag Ross. I'm coming to you from Burbank, California. I'm trying to get a message across. I'm trying to tell you guys about some corruption that's happening right here in Adam Schiff's district. I can't tell you enough. If what I'm saying is true, our California legislature is a piggy bank for a select amount of attorneys that take these cases, they vacate them, they make deals behind closed doors, but they have to get remember, they have to get the verdict first. You don't just get to make a private bargain. You have to actually take it to court and get a verdict. Once you've got a verdict, now you've got the bargaining chip. Okay, so what I want to do, I'm reading this. I've attempted to read this a couple of times and I've failed miserably and I've erased the tape, but I'm going to try one more time. This is an article that was written by a guy named Kenneth Reich, and it's called An Equal Chance. 2 ways our California courts keep decisions under wrap. He says California, the state courts, have emerged as national champion of secrecy and occasionally even erasing judicial decisions. I'm not speaking here about judges sealing court settlements involving the reputation of big insurance companies or other companies. That's happening in most states. Now, I'm breaking off real quick. Think about that. So once you win, they can just seal the court settlement. So what happens to Ross Gunnell? Ross Gunnell wins $6.5 million. I won a $6.5 million jury verdict, of which I got no money. And today I have a bill that is around $1.8 million. I'm going to show you the bill in a few minutes, okay, just so you, but I'm going to get through the article, okay? It says, rather, this has to do with stopping publication of court decisions through ordering them depublished or, in extreme cases, vacating them altogether. Now I'm going to do an Adam Schiff, and I'm going to put my name where it says, let's say someone, I'm going to put my name in, okay? The last procedure is known as vacatur. Let's say Ross Gunnell wins $100,000 in a court decision that might be a precedent for other cases by injured consumers. But the defendant agrees to pay $150,000 on the condition that the plaintiff agrees to stipulate that the court decision be reversed. That way, no precedent. And right off of the bat, I want you to think of the social stigma about that. Really? So Ross Gunnell wins and I can just sell my verdict. I can just sell it, and to hell with every one of the film workers that are still in those labs and they're still getting poisoned with the same stuff. These people want to buy the privilege of saying that what we are doing in the film labs, yes, it's killing everyone, but can you give us some more time? That's what it was about, okay? Gunnell versus Metro Color. That's what it was about, okay? Now, so now we have no precedent. Think about that. You're taking away the precedent. You're taking away the right to say what happened in Gunnell versus Metro Color should not happen to anyone. But you buy the verdict. You buy it. You buy it for 1.5 times the dollar. So Ross is 6.65. What's that? About $10 million. So all of a sudden it's worth $10 million. And you look at it. Most people would say yes to that. It's a pretty darn tempting deal. Okay? So now you go, that means the big money defendant can reduce the possibility that one decision will lead to a whole series of costly claims. Well, if I won $6.65 million for what they did to me at Metro Color Film Lab, and they deemed that the film process itself, you heard me, was so dangerous, why did the other 4 labs stay open for 13 or so more years? And we all know the answer, because it's money. Without film in Hollywood, what do you have? You have nothing. So yes, you guys, I killed film in Hollywood. That's what I did. And all of you people that are digital editors, you're welcome. Let's, okay, so yeah, the big defendant gets away with it. That's legal in California thanks to a 1992 Supreme Court decision designed to encourage private settlements during appeals process. Now, a private settlement, think about private. You don't even have to tell me. It's so private, you don't even have to tell me. I can go to the California State Bar, go to Nancy Brown, the chief prosecuting attorney at the California State Bar in 2003, and I could hand her my complete complaint saying they vacated my case. And she said, yes, they did. And there's nothing I can do about it. Now imagine I'm talking to the top cop, and that's what they said. Does this sound familiar, Donald Trump? It sounds familiar. This sounds like the courts in California. And who are you dealing with? You're dealing with Adam and the shifty of the shiftiest shift. Okay? So, let's see. in most of the rest of the country, so they can do it in California, but in most of the rest of the country, as a result of a unanimous 1994 United States Supreme Court decision written by conservative Justice Antonin Scalia, it's not. Antonin Scalia was so upset about what he saw the state of California doing. He said, I'm going to make sure that it is illegal everywhere. I'm going to put a federal rule in place. And that's what he did. And look what happened to him. Okay. Also, California is the only state whose Supreme Court made depublished decisions. Depublication, a device only the Supreme Court can use, is even more common than vacatur, which is why I have a stamped Supreme Court document that says Metro Color versus Gunnell, and it's stamped by the court because they had to. When they vacate a case, they have to at least stamp the document because it has to be approved by the Supreme Court. That's why mine went all the way through the Supreme Court. And then they charged me post verdict charges of $327,000. But you know what? Vacatur happens after the verdict. So you get the verdict and then they do the vacatur. So you're charging me for something that's required by vacatur, and you're going to keep the money, all the money, and you're going to give me nothing. And you're going to chase me and my 7-year-old daughter and my 9-year-old son. You're going to chase us down forever. Martina A. Silas and Bernie Bernheim, a.k.a. Stephen J. Bernheim. Oh, let's finish this article since we're talking about these people. Who would do this kind of stuff? Let's find out. In 1996, more than 90% of the decisions of the appellate courts in California were not published, mostly in accord with standing rules that only something new or significant be recorded. Depublication goes beyond that, and the Supreme Court need not explain why it's taking the action. Some decisions, though, are depublished because the Supreme Court decided they are not in sync with what the Supreme Court wants or prefers. Once a decision is depublished, it cannot be used as precedent or even cited in briefs. Gunnell versus Metro Color cannot be cited in any other film lab cases. And I showed you, I'm a result of 138 film lab cases before me, where they got to be, I guess they were private and I'm not supposed to use theirs. Well, I have all their numbers. So that's why, and I don't care if it's private. I really don't care if it's private. You guys can all kiss my butt. Now listen to this. Okay, so they don't get it depublished. Los Angeles attorney Bernie Bernheim calls this a judicial pocket veto. It takes a case out of the record without a full Supreme Court review. And who took my case out? And who was the guy in charge of my case? Who was he? What was his name? His name was Bernie Bernheim. Let's look at Bernie. Look at this. Here he is. Look. Stephen J. Bernheim and Bernie Bernheim. Same guy. Same bar number. So wait a minute. So I got Bernie Bernheim is on my case. And he's talking about vacating these cases. Oh, that's great. And then it goes on to say Gene Anderson, a New York trial attorney, asserts that if depublication is added to vacatur, the insurance people manage to vacate more than 50% of the California decisions against them. In other words, these rulings cannot be used by others to build cases against the companies or film workers, okay? He apparently drew his conclusion from a 1989 lawyer article citing industry attorney Ellis Horowitz as claiming a almost 50% success rate at getting adverse precedents depublished. Gunnell versus Metro Color. And after they depublish it, they chase you down. They chase you down. They come to your house because there's only one way to get to you. If you're a guy who says, oh, I have to go private, they come to your house. They come to your house and they try and get other people to sue you. And then what? You got money in a bank somewhere? And if somebody wins a lawsuit, like the person that came to my house and tried to harass me at my own house and then, bring me to court, if she would have won, do you get to pay her? Would you have paid her? I know she walked into court with one of your letters, Martina. That was amazing. I couldn't believe that you would give her a letter. So these are the people. So Anthony Klein of San Francisco also assailed that the decision vacatur will inevitably include the unknowing judicial effectuation of some highly questionable private bargains. We agree. It will inevitably, the opinion is the public act of the government, which may not be expunged by private agreement. So in other words, when I won Gunnell versus Metro Color, I won something that protected all of those film workers. And you guys bargained it away, and you chased down the whistleblower. I am the whistleblower. There is a whistleblower. Everybody says, where's the whistleblower? I'm right here. I am right here in Adam Schiff's district in Burbank, California. When I went into his office and I read my jury verdict to his door, immediately he didn't want to hear about whistleblowers. Forget it, we don't need whistleblowers. We do need whistleblowers. I am the whistleblower. Everything that I say here, I can prove. I can prove everybody's name. I can prove what they say. Martina says, oh, I didn't win. Here's what she said to Joseph L. Pauler on May 1 of 2000. May 1, she'd already got her money. I think she got her money 3/16 of 2000. So this is May 1, 2000. And it says, as you know, I have a good track record arguing on behalf of union workers, having obtained a verdict of $6.65 million for just one worker injured at Metro Color Film Labs. In that case, I successfully argued to the jury that management had committed a battery on my client so that his suit was not barred. However, that case is the exception rather than the rule. Most workers lose on workers' compensation issue given the current state of the law. I won. You bragged it to him. You bragged it. Martina, you also bragged it to the Trial Lawyers Association of America. When you sent them a letter, you told them everybody forged my signature, so you let people commit crimes during my trial. And then you voted yourself Trial Lawyer of the Year, or Bernie voted you Trial Lawyer of the Year in 2000. And you were the trial lawyer because you did. You took in all that money, and it's in your pocket. And it's in your pocket. You put a bunch of it in Adam Schiff's pocket. A bunch of it's in Bernie's pocket. And if you go to Bernie's site, what are you going to see on Bernie's site? Oh, you're going to see all the original names of all the original people that were in my suit. And he settled with them because what, you sell him the verdict? Is that what you did, Martina? Because that's what I think you did. I think you took a portion. You said, I want this, and then here I sell you this. And then that's what he gets, and he gets to brag that he's the winner. And that's what you two did as partners. That's right, and that's what you did, and I am sick of it, and I'm not going to pay for it, and I'm not paying your $1.8 million bill. So if you guys want to see it, I'm going to show you the bill, if you don't mind. Here. Okay. Here's her letter. This letter right here. It says something that's so classic. Everybody in the world should see it. Sorry about that. But look at this. Right there, that says Judge Boland, now an Associate Justice of California Court of Appeals, Division 2, where our appeal was decided, acknowledged that this ruling was inconsistent with several prior rulings he made in our favor on the battery issue, but claimed that he had a right to change his mind. He changed his mind. You wrote me a letter saying he changed his mind. And then you say, the Court of Appeal also found the facts did not constitute a criminal battery. We were in a civil court. They don't do criminal in a civil court. That was, just like the, who that got out. They said, hey, this isn't the National Labor Relations Board, so those people are out until further notice. And what notice did you take with them? You know what you did. You know exactly what you did, Martina. Okay? And I'm telling you what, I'm not paying the bill. I'm not paying the bill. You owe me money. And I want to know where my money is. Morris, he talked about an unliquidated claim. What's an unliquidated claim? That means you got a claim and you stuck it in a bank and you didn't tell me anything about it, and you know you didn't. You never told me. You kept that money, you put it in your bank, and you can let it sit there and you're sucking interest off it. Now I owe you $1 million. $1 million. Where's the bill? I want to show you guys a $1 million bill. If you guys had a $1 million bill, you'd be upset too. Let me tell you something. That's the kind of a bill that nobody can stand. Oh, but look at this. Here's this. and Horvitz and Levy. And look at those names. Warner Brothers, Sony Pictures, Lorimar Productions, Metro Color Labs, Columbia Pictures, Metro Goldwyn Mayer, Lab, Warner Communications, Sony Corporation of America, Time Warner. And in the end, you send one thing to one court. Look what it says. This one says Sony Pictures et al. But when it got to the Supreme Court, what does it say? Metro Color Laboratories Incorporated et al. Defendants respond. When you got 22 defendants, you can take the ones that won and you take all the money, and the ones that didn't win, you send them through and then tell the guy he lost. It's freaking brilliant, man. It's brilliant. It took me forever to figure it out. And Justice Ronald George says if there becomes a pattern of abuse, then he will review his decision at that time. You know what, Ronald George? You really ruined the state. You helped Adam Schiff, the shiftiest guy ever. Look at Adam Schiff. What's he doing to the president? He won, and he's just not having it. And he's taking his private court and his private everything, and it's all private, and you guys don't get to know nothing because that guy is a communist. That's what you are, Adam. I don't know how in the heck you, a communist, got voted in over here, but these people must be all brain dead from too much chemicals in their head from the film labs. And you know what? I'm going to leave it at here. I have a lot more to say, but this was pretty good. I had a couple stumbles. I apologize. Remember, no script.